Good morning, everybody. As we are allowing participants to join us gradually, we will start in a few minutes. I just wanted to ask, as you are all being welcomed into the room, if you could just make sure that you're all on mute in order to ensure smooth proceedings for our meeting today. So please just give us 1 or 2 minutes while we enable other participants to join the session. Okay, everybody, we're just going to give it 1 more minute. Just bear with us 1 more minute and we will get started. I just wanted to inform everybody that in order to make sure that our system doesn't get overcharged, we will only ask those who, when they're speaking, to put their cameras on. Otherwise, we'll ask that everybody switches their camera off. If you have any comments, or want to raise any issues, please do use the chat function that is open and available for everybody to interact. We will also be having a series of polls during the course of this webinar, where we will like to get your feedback and thoughts on a couple of very topical issues. I think we'll be having about 3 or 4 of them during the session, which will also give you a chance and give us a chance to take the temperature a little bit about the issue that is before us today. I see that we have quite a number of participants, so perhaps we can get started. So welcome everybody. Welcome to this webinar. My name is Abigail Noko. I'm the regional representative for South Africa at the Office of the High Commissioner for Human Rights, and I'll be your moderator today. This webinar is very much a joint venture between the Center for Human Rights at the University of Pretoria and the Office of the High Commissioner for Human Rights, with whom we enjoy really excellent partnership over many years. And for us, we see this as yet another great example of strong collaboration in the spirit of upholding universal human rights standards. As you all know, COVID-19 is a pandemic that has brought into stark relief inequality and the most pressing human rights concerns around the world. And one of the paradoxes that is before human rights practitioners, scholars, and activists alike is to unpack really the limits of assembly in the context of COVID-19, a pandemic that is contained through physical distancing and will no doubt be the new normal, as everybody is calling it, for months to come. From the perspective of the United Nations, of course, the Secretary General and the High Commissioner for Human Rights have both made it unequivocally clear that people need agency and voice in this crisis. And this includes, of course, freedom of assembly. From the streets of our big cities and towns in Southern Africa and beyond, to chat rooms and online webinars, we are seeing that freedom of assembly is critical to the response to COVID-19. It is essentially for this reason that both the Center for Human Rights and the Office of the High Commissioner for Human Rights decided to organize this webinar on the right to assembly in Southern Africa in the context of COVID-19. So what is the purpose today? Well, it is quite simple. It's really to stimulate a discussion about issues of concern regarding the exercise of right of peaceful assembly during COVID-19, but also to really use this as an opportunity to identify some good practices. And in terms of the proceedings today, we will start with a series of presentations from our esteemed panelists, whom I will introduce in a few minutes, and that will be followed by questions and reflections by participants. We will take questions from all of you who are interested in either making a comment or posing a question to our panelists by raising of your hand, the raising of your hand function, or by using the chat function. I will try my best to keep an eye and put together a speakers list for that. And as I mentioned at the beginning, we will also have a series of polls to test the mood of our participants and also to distill priorities when it comes to freedom of assembly in the context of COVID-19 in Southern Africa. Please also note that this is a webinar that is being recorded and I believe also live streamed as well. So we have a maximum of 2 hours. We will see how the discussion goes. And we hope really that this discussion today will assist both the Center for Human Rights and the Office of the High Commissioner for Human Rights in sharpening our focus, broadening our scope and understanding of the issues at stake, and also hopefully help us produce more relevant guidance to this sub-region. So in order to get us started, I will then now invite Tiruna to administer our first poll, really just to get your views on some of the most pressing issues in the region with respect to peaceful assembly. So Tiruna, you should now see already on your screen the first poll. We will ask you to select what you believe to be the 5 most pressing issues when it comes to peaceful assembly in Southern Africa. I will just give you 1 or 2 minutes to do that, and then we will continue. It will also give me a chance to respond. Okay, whilst participants are continuing to fill out that first poll, and if we have time at the end, we hope to be able to put up the poll results. Whilst participants are still filling out their poll, I will now perhaps use the opportunity to really, again, welcome our panelists today and perhaps just do a little bit of an introduction to get us started. So first of all, I'd really like to welcome Professor Christof Heyns. As many of you know, Christof is a professor of law at the University of Pretoria and also a member of the United Nations Human Rights Committee and Rapporteur for General Comment number 37 on the right to peaceful assembly. He is also the former United Nations Special Rapporteur on extrajudicial, summary, and arbitrary executions. We also have really the honor and pleasure of having Clément Voule with us today. He is the United Nations Special Rapporteur on freedom of assembly and association. He has assumed this mandate since April 2018. And prior to his appointment, he led the International Service for Human Rights to support human rights defenders from states in transition and coordinated the organization's work in Africa. Clément also worked as the Secretary General of Amnesty International section in Togo. We also have the pleasure of having Makanatsa with us today. She is the Deputy Chief of Party for the American Bar Association, Advancing Rights in Southern Africa. She has previously worked as the Executive Secretary for the Zimbabwe Human Rights Commission, the Chief Executive Officer of the SADC Lawyers Association, and as a magistrate in Zimbabwe. We also have the pleasure of having us Prof. Stewart, who is an honorary professor at the Center for Human Rights at the University of Pretoria, specializing in the use of force under international law. His book on police use of force under international law was published by Cambridge University. He is the project coordinator of police use of force worldwide and right of assembly websites. And then we have Priscilla, who is with us today also all the way from Zimbabwe. She is the director of monitoring and inspections at the Zimbabwe Human Rights Commission. Priscilla is one of the pioneer directors at the Commission as one of the first members of the Secretariat. She also worked in the Ministry of Justice, Legal and Parliamentary Affairs in Zimbabwe. So I will be giving each one of these esteemed panelists 10 minutes to, really make a few remarks, after which we will proceed with a Q&A. So first I would like to turn to Christof Heyns. And really just ask Christof the question, you are, as I mentioned, a member of the Human Rights Committee and a rapporteur of the General Comment number 37 on the right to peaceful assembly. Could you really help us frame the discussion today by telling us or reminding us what the essential international human rights standards on the right of peaceful assembly are and how they relate to COVID-19? Over to you.
Great. Good morning, Abigail, and good morning. I see a number of people who are colleagues and friends over many years, and it's a pleasure to join you in this online assembly, I think, that we have at the moment. So I'd like to respond to your question by also perhaps indicating what the UN has done on this in terms of identifying some of these international standards. And I think it's good to start off by thinking of it as there's really, when one talks about COVID and peaceful assembly, there's really a sort of a clash of two competing impulses. The one is COVID, a public health emergency, contagious, which points in the direction of distancing, of people not moving, staying at home, a centralization of power to enforce this, and power which is easily abused. On the other hand, human nature is such that we want to join forces with others. We want to engage with each other. One may call it Ubuntu. One may call it many different terms. But that we want to collectively address common problems and express our identity and pursue our goals. And that is recognized, among others, in the right of assembly, the right of people to come together. And of course, in some cases, these things come into conflict. On the one hand, to keep people apart. On the other hand, then to people that want to come together, among other things, to address the issue of centralization of power, or as we've seen in the last week, and in many other instances, in fact, as well, to address underlying structural problems. So there's a tense relationship and the potential for conflict. And of course, the question is, how can human rights assist to some extent to mediate these issues? And I think one of the challenges really is to make sure that human rights does not lose its moorings during this time because of the challenges that we have. So what the UN has done, if one looks at what has been said by the Secretary General, the High Commissioner for Human Rights, also the Special Rapporteur, and I'm sure Clément will brief us on that, and he's made some very useful public press statements, 14th of April and later as well. And then in the Human Rights Committee, where as you mentioned, I'm currently a member, we've looked at two particular issues. We issued a guidance on states of emergency, and we are working on the General Comment 37, and we've been doing that a long time before COVID, and the idea is to finish by the end of this year to draft a interpretation of Article 21 of the Covenant on Civil and Political Rights that sets out what are the international standards there. And of course, the underlying issue is that one is balancing rights, among other things. There's a right to life, there's the right to health, the right to movement. These three rights have been identified by various UN officials as central, not the only ones, but central rights. And then, of course, what comes into the picture is that the state has an obligation to protect life, has an obligation to protect health, but also obligation to protect a peaceful assembly. And then, in order to protect life and health, there may be some restrictions on the right to movement and the right of assembly that may be required on a temporary basis. And many of the people who've spoken on this from the UN side have emphasized that it's legitimate that these restrictions will be imposed, but also that they should not be permanent. And that's really, I think, the main point that I want to convey, is that even if restrictions are necessary and along the way mistakes will be made because it's an uncertain situation, the main thing is to ensure that the restrictions do not become the new normal. And also that the valid concerns about COVID are not a pretext for restricting rights in an undue fashion, in particular in the long term. And also, if one looks at the right to life, if I can refer to the previous general comment of the Human Rights Committee, General Comment 36 on the right to life, what was emphasized is that what is at stake is not merely the continuation of bodily existence. It is a life in dignity that is protected. So if one says it's part of human nature to associate with others, and that's part of what a life in dignity is, it's not as if we on the one hand have a right to life, mere survival, bare existence, and on the other hand, assembly, but these things are really integrated as well. And a life in dignity entails that one can actually engage with others as well. So if I can set out, perhaps I thought it would be useful to give a sense of two elements of what we've done in the Human Rights Committee. One concerns derogation of Article 21. And so there have been over the years a number of derogations of Article 21. 15 of them are now in the context of COVID. And in many cases, states declare states of emergency or states of disaster, as we have in South Africa, or impose other restrictions without derogating formally. So if one looks at Southern Africa, for example, there are states of emergency in Botswana, Lesotho, Mozambique, Angola, disaster in South Africa, Zimbabwe, and in the other Southern African countries, various forms of regulations. None of them have declared a derogation to the UN system, but of course the principles remain applicable, and which requires that a derogation must be promulgated for a certain period. There must be notification. It must be necessary and proportionate, and some rights may not be derogated from. So peaceful assembly may be derogated from, but the right to life may not be derogated from. And again, the emphasis is that it should be temporary. And so in this guidance that the Human Rights Committee issued about a month ago, we set out that these are the standards and that they are applicable. For General Comment 37, just to give you a brief overview of the question being, what are the international standards? On the process itself, as I mentioned, this has started a long time ago, actually last year, and the idea is to finish it this year. So it's a 2-year period during which we've had inputs from I think 140 stakeholders, and we are now in the second reading. So we had a draft and we took into consideration what the stakeholders said, and now we have our first draft completed, and we had another set of inputs also from states, and actually just before COVID struck, we were busy on the general comment in March in Geneva. And then our meeting was suspended ourselves, and we will now in July, we will meet again virtually. And the idea is to largely complete this general comment now in July, because we can do this online, and then in October probably to finalize it. So the general comment is aimed to be an authoritative interpretation of what peaceful assembly entails. It sets out the rationale, and I think it's important perhaps to go back to that, that peaceful assembly protects people's ability to collectively shape their society, to participate in governance in the way in which they are governed into realizing other rights. And also it emphasizes in the rationale that it does inevitably in some cases entail also some level of disruption, and the state and society as a whole have to accept some level of disruption that can potentially come with the exercise of peaceful assembly. It's not an absolute right. It can be limited, but all limitations must be justified. All restrictions must be justified. In terms of the scope of the right, the general comment sets out what falls within this right. And so once it falls within that right, certain obligations are created for the state, and then the state may in some cases limit the right. So the question is, what is protected by this right? And so it's peaceful assembly. And that raises the question, what is an assembly? So is less than two people, one person, a sole demonstrator, is that protected by Article 21? The general comment says that generally assembly means that more than one person gathers, but single protesters are protected by freedom of expression and so forth. So more than one person gathering, but then the question is, where can they gather? So they can gather in public, it's recognized also they can gather in private property. This can take place indoors, it can take place outside, and then of course it can take place offline, but the question was also, can it take place online? And there's I think a wide acceptance today. This is a new development really to also recognize online assemblies, and that's also recognized in the draft as we have it now. And this is of course also quite relevant in the time of Corona, when many of the assemblies that previously and the interactions that previously would have taken place offline or online. And this brings in all kinds of issues concerning the digital divide, for example. And I think also what I see as quite important is that the possibility of online assemblies should not become an excuse not to allow offline assemblies. So the argument from the state cannot be, well, you have online, go and assemble there, and for that reason we will not have offline assemblies. So that's a danger to look out for, although as will be mentioned, limitations can, during the time of Corona, be based on real in-person assemblies. And then of course assemblies can be organized, but they can also be spontaneous, and they can also be counter assemblies. So you can have one assembly pushing a particular point, and then another group who are also protected are also pushing their own point. One of the big questions is, what is a peaceful assembly? So not violent. And I think the important point there is, even if some violence occurs, it should not be attributed to the group as a whole. And then of course also that if there's a danger of violence, if there's incitement to violence or imminent violence or the intention of violence, in such cases that can also be attributed to the particular individuals who are involved in that. But the general rule is not to the group as a whole. What are the obligations on the state? That it has, any restrictions have to be content neutral. And this is, I think, quite important in our context as well, is that the fact that there may be restrictions cannot lead to a situation where the purpose is to say, we as a government do not like what these people are saying, in particular political opposition, for example. So it must be content neutral, and in particular the coronavirus cannot be used, as it has been used in some instances, to stifle dissent in general, but the idea is really to stifle the opposition in particular. So it must be content neutral, and people must be allowed within sight and sound to express themselves. And this thing comes in again with the issue of social distancing. If people want to gather on a particular square and express themselves there, in general, they have the ability to do so within sight and sound, but the restrictions are of relevance there. And so the duty of the state is not to unduly interfere with assemblies, to some extent just to leave it alone, but also in some cases a positive duty to facilitate and protect participants. For our purposes, restrictions are important. So what are the limitations on the limitations? So I think the starting point is there's a presumption against restrictions. There's a presumption in favor of allowing assemblies. So restrictions need to be justified. The general requirements of legality, it must be based in law, it must be necessary, the restriction, and it must also remain necessary. So if there, at one given point in time, if there is a need to engage in a restriction, this may change over time. And I think with COVID, that's very clear that this is not a carte blanche that governments can have to keep it into infinity. And restrictions must be proportionate. The grounds for restrictions can be national security, which normally relates to the use of force, but more relevant for us in the context of COVID, also public safety, so danger to the life and the physical integrity of people. So COVID, yes, certainly in terms of one of the grounds for restriction, if it's necessary, if it's proportionate, in order to protect public safety, that is a legitimate ground. And then also public health is a ground which certainly is invoked by many states, but again, subject to it being necessary and remaining necessary, and also the protection of the rights and freedoms of others. So the one element that I just want to flag here is that in a number of countries, the issue has come up about the number of participants. So in the Netherlands, for example, recently, there was notification there are going to be 250 people on the dam, the public square there. 5,000 people eventually went there. The same is happening in Tel Aviv, and I'm sure this will happen in many other countries as well. That also in the context of Black Lives Matter, that the number of people who eventually come exceed what was notified. And then the question becomes, how should the state respond to that? And certainly the danger is that the response will be, this is a reason for a blanket ban on all these kinds of restrictions. So paragraph 69 of the general comment says, in general, states parties should not place a limit on the number of participants in assemblies. Any such restrictions can be accepted only if there's a clear connection with a legitimate ground for restrictions. So that could, for example, be public safety. If there is a bridge that will collapse, if there are too many people, that can be a ground for limitation. And on the same basis, states can at some point, I think also based on their obligation to protect life, say that we have to restrict the numbers. But I think this is something that needs to be flagged, and this is something that needs to be addressed. So if there is a notification that a certain number of people are going to address, the response to that, I would not see as something that requires criminal intervention, but in a way, good practices in terms of the state. They're notifying that this particular putting up signs, this particular gathering is only, the notification was only for this number, and in a way try to preempt a situation of confrontation, that people know about it, so that even if they exceed it, some level of disruption must be accepted, but that they can, in a way, try to control the situation without going to more drastic measures. I think issues such as law enforcement officials and their duties too, Marsland will deal with that, and also with, in terms of what comes from the UN, the less lethal guidance that the UN issued last year in its advanced form, and it should come out by the end of this month, the United Nations Human Rights Guidance on Less Lethal Weapons in Law Enforcement, which supplements the basic principles on the use of force. So just to conclude from myself, I think my central message is that the challenge to civil society, the challenge to states, the challenge to the UN is to make sure that the human rights structure, even if it has to be adjusted to the current situation, remains intact, and the right of peaceful assembly, because of the rationale, because of the central role that it plays in us being able to shape our society and to protect all our other rights, that there's a pushback to the normal, which is that the right will be fully recognized. Thank you.
Thank you so much, Christof. You've really given us a very comprehensive overview. I thought I was going to nudge you with some more questions, but you've been very detailed in your response. And I think what you're saying about this whole notion of balancing of rights, that freedom of assembly is not an absolute right, but can be subject to limitations that have to be justified, is extremely important. That these restrictions must be content neutral and not be used to, sort of silence dissent or disable freedom of expression. One amongst many points that you have raised, and especially as we're beginning to see the emergence of protests of various natures, including in the context of pre-electoral political rallies, including in Southern Africa as well. So I think this is a very good segue now to give our Special Rapporteur on freedom of assembly, Mr. Clément Voule, an opportunity to, say a little bit more about, what you're noticing in terms of the trends. You, of course, are in touch with individuals, different organizations. In your work, you are responsible for producing reports on this issue of freedom of assembly, and you yourself have issued guidance on this topic in the context of COVID-19. So when you put all this information together, what would you say are the emerging issues and challenges with respect to freedom of assembly in the context of COVID-19? Perhaps you can try and take that a stab, and then we'll see if there's some follow-up questions. Over to you, Clément.
Yes, thank you very much, Abigail. And first of all, let me also thank the organizer of this meeting, including the Human Rights High Commissioner office regional office in Southern Africa, but also the Pretoria Center for putting this webinar together. And since the outbreak of this COVID-19, one of the things also that I always trying to push is the importance of right to information, to ensure that people are aware of what is going on. People are aware also on some of the decisions that their government is taking in order to stop the spread of the coronavirus. Unfortunately, what we are seeing today is that coronavirus in some way give a pretext for some government to limit some of the rights, in mainly the right to peaceful assembly and the right also to movements. We also, Christof highlights some of the international standards, so I'm not going to elaborate more, but we saw that since the outbreak, one of the things that many governments did is also to declare the emergency. Some of them are formal emergency, as you know, under the International Convened Civil and Political and many regional instruments. As Christof mentioned, there is also a situation where government can resort to the derogation of certain rights. And some governments made it formal, which is required by this International Convened and Civil and Political Rights, but also other regional body, by informing the Secretary General, making sure also that the body that is, which is the committee in the case of the International Convened on Civil and Political Rights, are informed and knows exactly what are the rights that the government want to limit because of the threat, because of this emergency situation. But we also saw in many cases also where the government also resort to this limitation, what I'm calling de facto limitation, but without necessarily informing the Secretary General, which means also that there is a lack of information even at the national level, what are exactly the right that the government is limiting. But in the practice, we saw that the right of freedom of association was the one that was mostly targeted, the right to assembly, the right to movement, and we also saw that there was, in many cases, the pretext of this COVID was used sometimes to give more power to the country that is needed really to address the threat. As I mentioned at the beginning, and I think Christof was saying that also, is that the limitation of these rights should be necessary. It should be proportional. And when, for example, some of the state of emergency give the more power to the government, and sometimes also is reinforcing the government power over the parliament, and like what we saw in Hungary, it means that there is a problem there, because then there is a question of the necessity. Is it this power given to the government, this excessive power given the government, is very necessary to address the COVID? And we saw also in many countries, some of the example that was given to me was also that the committee that is supposed to address the COVID-19 spread in the country was, for example, chaired by the military. You know, so meaning that the COVID issue now is becoming more on a security issue. That's not the problem. And we need to, and I emphasize this in many times, we need to understand that the COVID, the COVID spread and the COVID issue is not just about health issue, but it's also about the human rights issue. So we should be making sure that in any cases where we put those kind of measures, we need to ensure that human rights are respected. We need to ensure that all of those committees also can include human rights aspects so that they can explain how the government can resort to certain limitations without undermining the exercise of the fundamental rights. There will be some limitation, but not a limitation that is over the what is allowed by the international convention and civil and political rights. And in this context, I want also to say that because many governments also did not consult with civil society, they did not consult with community, they did not hear about community, what are the measures, how those measures are adapted at the national level. We also saw that there is also imposition of certain practices like the curfew that limit the gathering. And sometimes the big question is that, okay, when you impose the curfew and you say it's only during the night that people are not able to go out and everything, and then you leave during the day. The question is really, is it the virus spread only during the night? So I'm not saying that it is not, I mean, it may respond to the reality of the country, but it has to be done in a way that there is no use of power to repress. Because we saw that in many cases, because of this curfew, many law enforcement use excessive force. And in many cases, some video that we saw where people are beaten on the streets by the military, by the police, while the police themselves are not wearing any masks, they are not protecting themselves. So the big question is that beating people on the street, using excessive force, detaining some medical personnel that raise their voice to denounce some of the measures taken by the state, which is not in line with their obligation, is really a measure that is conducive to stop the spread of coronavirus. So we saw that this excessive use of force, this COVID-19 itself, give only pretext for some governments to resort to the certain practice. I want also to underline that, as you know, we need to remember that in 2018, I mean last year, that the world was already going through a lot of protests. And some governments think that COVID-19 become a platform to stop that, than really trying to understand why people resort to this protest. How can we address those issues? How can we ensure that the measure that we are taking enjoy the public support? How do we make sure that we put in place some measure also that respond to our realities, but also at the same time can also respect our international obligation on protection of human rights. And what also we witness is also that the COVID also now raised, or we saw how the inequality increased. And because some of the measure was not, many governments did not consult, civil society did not consult the human rights aspect, we saw that there is also some measure that did not take in account that we are living in a country where we are not same. We don't have the same resources. And imposing, for example, a curfew or imposing lockdown to some communities that only live daily. You see, it creates kind of inequality. People lost their income, people lost their job, and you can see that some of the protests ongoing in certain countries is also to denote this inequality. And to say that it's not possible that we can impose the government can impose this measure without taking into account that we also need to enjoy our basic human right, the right to food, the right to clean water, the right also the right to life, which cannot be enjoyed if people are not able also to eat, and people are not able also to have the basic to eat. So the COVID-19 also shows also this increase of inequality. Another thing also that is important also to highlight is also this COVID-19 also, and I think Christof mentioned that also. It also shows how, because we are not able to gather, we are not able to communicate, we are not able to move, the internet becomes the only space where we are able to enjoy our right to peaceful assembly, our right to associate, where we even work, where we do everything that we can, where we connect with victims, where we connect with communities. But COVID showed that the internet divided is becoming a big problem. We saw that where, for example, in Western world, many civil society are able to connect easily. We saw that in global South, there was a lot of challenge in terms of internet connectivity, both also because of the internet cost. That's why before even COVID, I was arguing that is important also in order to ensure the right to access to the internet, to ensure also that the government puts in place, but also the tech companies ensure that the internet is affordable. There is no, it's alarming to see that the same cost of the internet, 1 giga in Western world can cost probably $1, where it will cost like $10 to in DRC in other countries. So this also means also that the government should also be ensured that in this particular time, they can also lift all the taxes on the internet service to ensure that people are able to communicate, people are able to have access to information, because the lack of access to information also is also the basis where people can rely on some information other than another tool. And in many cases, we saw that some governments want to control all the information. They don't want to put this information. They don't want people to know what is going on. And this is not a proper way to address the spread of COVID, or either to enjoy public support. So the internet divide remains. And Christof also mentioned also to you that since the committee was adopting this, the general comments on peaceful protests on Article 21, my mandate was also so active, also discussing with the committee to ensure also that the online space is also recognized, that's a space where people can enjoy their rights to peaceful assembly and association. And we see that that COVID-19 shows us that it's important both to protect this space, to ensure that there is no surveillance, there is no trolling, to also ensure that people are able to access to this. And I want also to invite you to also have a look to my report that I present to Human Rights Council on peaceful assembly in the digital age in 2019. So this report also highlights what I think is important also to ensure that online civic space is protected and is conducive and help also to push and to maintain our democracy. And another issue also that we saw is also the issue of election. And we saw that in many countries, either the election was postponed, which I'm not saying that is bad, but some of the election was postponed without any consultation, or in many countries, some of the election was organized without any consultation with civil society, with political parties. And one thing that I'm saying, and I will come to that when I talk about my 10 principles, is that it's important that COVID should not be a pretext to postpone indefinitely the democracy. It's important that the consultations, the participation of citizens have a means when the state is going through a challenge. We cannot say that let's wait until we address completely coronavirus and consult our citizens on how we address. No, you need the participation of people. This is the time where people have to say, we agree with the measure that you are taking, we don't agree. And elections are important tools for the participation. Election is a platform, is a core of freedom of association and peaceful assembly, is a core of democracy. And we have, and I mentioned this in my 10 principles, I'm not saying that we can organize election at any cost. What I'm saying is that when there is a decision to postpone the election, this decision needs to be collective. This decision needs to be made after consultation. And also when there is a decision to organize election will need to be organized in a way that it takes in account the safety of the people that participate. It also gives the equal platform to the opposition, like a ruling party. It also provides the means that are necessary for fair, transparent, and conducive election. And for me, that's so really important, because we saw that in some countries, election was organized without even listening to the issue of the health issues. But also in some countries, we know when we have information that some governments are postponing the election because they think already that this time organizing the election, they will not show any kind of progress because they handle badly COVID issue. So they don't want to organize. They are waiting for the time where they feel like they will be in the best position to do that. We are saying that no, democracy should survive over the COVID-19 spread. Another thing also that is important also in the witness, and because the COVID become this threat that we never seen, and we all want our safety. We all are afraid because the government at that time, when we were in the peak of the COVID, we saw that many governments control the information. So we are afraid. So many governments now take the advantage, and we saw that this advantage is rising of authoritarianism. Because though they are making decisions, there's a lot of decree that restrain certain rights or pass some laws that will never be passed if we are not in the, if it was not that we are in the middle of the COVID. So the lack of information, taking advantage of the fact that we all fear, that we all want our safety, and pass some of the laws or pass some of the decree that will never be accepted in any democratic society, I think is wrong, because it does not respect the proportionality. It does not also respect the obligation of the state to stick on the strict necessity of what is needed to address the COVID, but not to overpower the government itself in taking some of the decisions that people will never accept, or people will go to the street and to demonstrate. And I think this is what we are seeing today, that this is happening in some of the protests, because people feel like this. Sometimes that things are happening, they are not aware, and social inequality is increasing, there are some injustice, and people say, no, we have to stand. We cannot wait. We cannot wait to denounce what is called racism. We cannot wait 1 year. And let's also be clear that what we are living now, and from the expert point of view, even if we have the vaccine at the end of the year, we know that we will be living with the COVID for many years again. It will probably come like any disease, like a paludism, like other thing. So my question is that, can government continue to maintain those restrictions if we have to live 3 years with the COVID? So we have to be careful whenever. I know that in this particular situation, many governments enjoy the public support, saying that, oh, what we want is this disease to stop. But we know also that we will be living for it 1 year. We need to be careful that we don't destroy the basis of our democracy, just giving completely over our rights to the government to do whatever they can do. I appreciate how many governments are really standing forward to address those issues. But at the same time, we saw that many governments also are taking advantage of this COVID to reinforce their power and to completely destroy the basis of the democracy, things that they will never do if we are not in this particular station. My mandate, Abigail, is since the starting of COVID, were really, really active. And I developed 10 principles that I'm sure you will also share it with the participants, and I'm happy also to respond to any question. And for me, the purpose of this 10 principles is to ensure that it's becoming a checklist for civil society. Whenever you are in a country where your government takes the measure, you can also look at this and see if those measures apply to those 10 principles. And for me also, it's important also to recall the government that, yes, under the International Covenant and Civil Protest, you are empowered to take certain decisions whenever they strike, but you have to do it in a way that it's in line with the International Covenant and Civil and Political Rights. And those 10 principles also highlight the need to maintain democracy, the need also to consult civil society, the need also for public to participate, the need also today to reinforce the online space to ensure that this space where we all, including governments, civil society, we are all doing that, it does not undermine our privacy. It does not, that the government is not resorting to the surveillance to leak all information or to target opposition or to target dissident. So for me, it's also important that, and also you can also see that from other colleague, from this 10 principle, I launched a campaign around this 10 principle that those who follow me on the tweets can also see that. I also issue a video that explains more those 10 principles, both in French and English, and I will be happy also to share it with you, Abigail, so that you can share it with participants. But also that at the special procedure level, we did quite a lot. As you know, many of my colleagues, like I mentioned at the beginning, COVID-19 is not just about health issue, about human rights issue. All the mandates that are affected, they also issue a statement. And for the first time, we are able, as a special procedure, to have an informal discussion with the government at the Human Rights Council at the end of April to discuss about our concern about COVID and how the government are responding to the COVID. We appreciate that this is a disease that is new. This is put many governments in difficult situation. But what we are saying is that don't use the COVID to create another kind of disaster, to create another kind of trouble that we will not be able to manage. Because if you reinforce some of the measures, you take some of the measures without consultation, at the end, those measures will not enjoy people's support, people will go to the streets and people will denounce it. So we need a participatory approach in implementing but also taking decisions around those measures. I think I will probably stop around this, but also just highlight that for me is also important also that as an activist, as an academic, as lawyers, we need also to challenge those measures. It's only through challenging this measure at the national level that we will be able also to hear or to really put light on some of the gaps. And that's I'm also encouraged to see that recently Human Rights Defenders Coalition in Malawi, for example, was able also to challenge the lockdown, to ask the government that they need to respect what is provided by the Constitution. And I think those kind of initiatives, we would like to see it more. We like also to see more coming from at the international level, both for the special procedure to understand better, and then also to help to ensure that COVID-19 is addressed properly, is addressed collectively, but also that our democracy, our freedom survive to this COVID-19 disease. So let me stop here, and I will be happy also to have a conversation with you and any question that you have. Thank you very much, Abby.
Thank you so much, Clément. I was hesitating to stop you, but a lot of what you said, I think, is very, very interesting and gives us a lot of pointers to maybe have some follow-up from the participants. What I wanted to say also is that my colleague has posted on the chat the 10 principles that Clément was referring to, the Special Rapporteur. So you can consult that document. I would really recommend it. We're all using it in our work, and it's certainly worth referring to. And another of the participants also has posted your report on digital space, your recent report. And thank you, Clément, for producing those very informative guidance, because I think it really helps human rights activists and academics and the like to put into stark relief, as you said, the fact that COVID-19 is not just a health issue, but also a human rights issue. You've pointed to a number of things, and I'm glad that you raised the online issue, because I think COVID is bringing that issue straight to the fore. You also talked about COVID-19 should not be an opportunity to postpone democracy, which I think is really of crucial importance. Talked quite a bit at length about how the restrictions have lacked consultation and resulted in some undue excesses, whether that is in the form of curfews, excessive use of force, disruption to people's livelihoods, bringing or exposing inequality, and on and on. That's hardly a summary, but just a few things that I took away from what you said, as well as the experiences that you were able to bring to everybody. And there's one thing that you also mentioned, and that's the issue of surveillance and privacy. And I think, you know, it's a good segue, because our next speaker, actually going to be, I wanted to ask her precisely about this area. As you know, COVID-19 has, as we know, and as the Special Rapporteur has highlighted, Makanatsa, has led also to the rapid rise in surveillance and privacy. So as somebody who's both a lawyer and a human rights advocate for many, many years, how do these issues relate to the right of peaceful assembly during COVID-19? What are the red flags? What are the green flags that you are observing with regard to this issue of surveillance, privacy, right to peaceful assembly, and the addition of COVID-19? Over to you.
Thank you, Abigail. As you rightly point out, and I think as rightly pointed out by the previous speakers, we know for real that freedom of assembly has been under threat in some of the countries or in some of the jurisdictions in the region, even before COVID-19. But we also see that COVID-19 has given many of our governments a pretext to enforce draconian laws or create draconian laws, especially using the pretext of the declarations of states of disaster or states of emergency, which have somewhat allowed governments to make laws with little or no parliamentary or public oversight. Yet we see that many of the laws that have been passed by the governments actually have far-reaching implications on the different fundamental freedoms and human rights that citizens should be enjoying. So looking at the regional level, we know even when we are faced with a situation like COVID-19, when our governments are making laws, those laws should actually comply with the provisions in our different constitutions, balancing the need to deal with COVID-19, but also realizing or bearing in mind the need to continue to protect the rights of citizens. So when the laws are made, basically, they should be fair, they should be reasonable, they should be necessary, they should be justifiable, as earlier indicated. And at the end of the day, I think the most important thing is to make sure that the laws that are made or the limitations that are provided in those laws are not greater than what is strictly required in order to deal with the challenge or emergency that the different countries in the region are actually facing. So looking specifically at the issue of surveillance or regulations or laws, orders that have been made in the context of COVID-19, that touch on the issue of surveillance. We note that in the region so far, South Africa seems to be the only country that has passed surveillance-specific COVID-19 regulations in terms of their electronic communications, postal and broadcasting laws. And South Africa, again, I think compared to some of the countries in the region, is one country that has made an effort to consult. To some extent, I'm not saying the consultations were adequate, but they have made an effort to consult with civil society, other actors, and other structures in the country in the making of the laws. So when they made the initial regulations on the 26th of March, they actually put those out for public consultations. And we ended up with revised versions of the regulations, which were then gazetted on the 2nd of April in the country. Basically, the focus of the regulations is on using cell phones to track individuals who test positive COVID-19 and any person that they may have come into contact with. And the purpose is to ensure that government or the health authorities in the country are able to implement contact tracing and be able to deal with cases of COVID-19 in the country. We know that surveillance is never an ideal solution, even in a disaster or emergency situation, But the regulations that have been made in South Africa have to be understood, I think, equally as equally important in the context of controlling the spread of COVID-19 in the country, and which is why this contact tracing is viewed by the health authorities as important in order to deal with COVID-19. And under these regulations, telecommunications companies are required to provide information to the Director General of Health on the movement of people who would have tested positive to COVID-19 and any other persons that they might have come into contact with, using the cell phones of the individuals to track them. Having said that, we know, like I said earlier on, that there are fears when it comes to surveillance laws, and just an understanding of what some of those fears might be, or what some of those fears are at the moment. In repressive regimes, we know that the mere permission for such tracking or surveillance can actually go unchecked. It may allow some of the states to actually gather information that is not related to COVID-19 or any other imperative for that matter, which is supposed to do with situations at hand like disasters or emergencies, or even be used beyond what the law would have provided for. And therefore, in the context of the surveillance regulations like the ones that have been passed in South Africa, there are fears of infringement on the rights to privacy, including listening in on conversations or intercepting private conversations that are not related to COVID-19. And this is particularly concerning in the context of freedom of assembly, given that more and more citizens are coordinating their initiatives online before gathering physically. We've seen this in the region, I think in the context of this flag movement in Zimbabwe, where there was a lot of online organization before people actually gathered assembled to have their issues voiced or addressed. We've also seen that in the context of the total shutdown in South Africa again, which was mainly organized or online by the citizens before they went out to assemble or to express themselves through peaceful assembly. So under such situations, surveillance legislation can actually be used by authorities to gather information about planned peaceful assemblies and gather information about the key persons in the planning and intercept them in one way or another before the assemblies can proceed, and effectively drown the assemblies before people can even assemble. We also see that authorities may use the information gathered through such surveillance to preempt and disperse assemblies or arrest organizers or participants. And in more draconian situations, such information can actually also be used to abduct, disappear organizers and participants, and sometimes leading to torture, inhuman and degrading treatment. So we've seen it so often, even in the context of COVID-19 in the region. So having said that, we need to look at how the South African regulations, like I said earlier on, the government tried to consult with various stakeholders in the process of coming up with these regulations. And we need to see or check some best practices out of that process and what we think was done in order to guard against some of the possible excesses that may actually be used in order to take advantage of such regulations. So South Africa appointed what they call a designated COVID-19 judge to provide oversight over the implementation of the surveillance regulations and provide recommendations to government to address any possible breaches of citizens' rights using these particular surveillance regulations. And we think the provision or the presence of this independent oversight mechanism is actually important in ensuring that the regulations are used only for the specific purpose for which they have been promulgated. One other thing is that the gathering of the surveillance information is led by health authorities and not state security authorities who might use it for other purposes, including for policing and even extra legal purposes in the context of peaceful assemblies, as I said earlier on. So it's important, I think, that South Africa limited the use or the gathering of information using the surveillance regulations to the health authorities in the country and no other authority that has got no use or no need really directly related to COVID-19 in the use of such information. I think the previous presenters also spoke about the need for regulations to be time-bound to ensure that they don't continue to be used even after the emergency or the disaster that a country will be dealing with is actually passed. So in the context of the regulations that have been passed in South Africa, the use of the data that is collected for purposes of contact tracing is actually time-bound, and it must be destroyed or anonymized after 6 weeks after the end of the declaration of the state of disaster in the country. And I think the need for the regulations that are being made under COVID-19 to be time-bound cannot be overemphasized. We also see that in these regulations provide that individuals that actually surveilled as part of the contact tracing are supposed to be notified at the end of the state of disaster that they were actually subject to COVID-19 surveillance. And this is important, I think, in order for citizens to be aware that their information was gathered by government, and if they've got any concerns regarding the information that was gathered, they will be able to address those. But I must say that even with all these measures in place, there's no guarantee really at the end of the day that when it comes to actual implementation, these tenets that actually provided as safeguards will be respected in reality. And like I said, we see that South Africa, compared to other countries in the region, has actually been more consultative, has been more open when it comes to the promulgation of some of the regulations, something that we definitely cannot expect to happen with regards to the other jurisdictions in the region. We have seen that even before COVID-19, our region had other surveillance infrastructure that was in place, that was being implemented by governments, by private citizens, and by other institutions outside of the states of disaster or emergencies that we are currently dealing with. And I think the issue of the use of closed circuit television has become a permanent surveillance feature in many of our cities in the region, and often with little or no regulation about their installation and use in some of the situations. We agree as well, I think, that CCTV surveillance can be and has been a useful tool that contributes to public safety and security, as well as the protection of people and property, and can be used as, I think, as a useful tool in investigation of crime. But again, the challenge that we can see with such forms of surveillance under the current situation where people are actually being ordered not to assemble in the context of COVID-19, the lockdown measures, the social distancing requirements, and even in situations where people have got a legitimate reason to assemble and gather, we see that in most of the situations, our governments are trying as much as possible to limit those gatherings, to stop people from assembling, and therefore, in a way, stifling those rights that are provided for in the various constitutions, but also in international law. So the existing surveillance infrastructure, like the CCTV surveillance infrastructure that we see in some of the countries, can actually be used, I think, in some of the regimes to breach the right to privacy and target citizens who participate in peaceful assemblies under the current circumstances. I think most of the time when citizens feel that it is necessary or it is imperative for them to assemble despite the COVID-19 situation, then in such situations, we then see the use of the surveillance infrastructure like CCTV being used to track and trace individuals and having them arrested for gathering or expressing themselves in public. So those are some of the measures that are in place, some of the infrastructure that is being used and that has got impacts. on the rights of citizens in the region. The example that we have given, I think, about South Africa should be an example that should be followed by the other countries in the region in the event that they need to put similar legal provisions in place to do with the contact tracing under COVID-19. But also we should be worried, I think, at the end of the day about how safe citizens would be with such laws in place, especially if we look at the challenges that we see in some of the jurisdictions in the region. Maybe to conclude, I would also like to say that as we deal with the issue of surveillance, we also have international best practices. If you look at the UN Resolution 68, 167 on the right to privacy in the digital age, it emphasizes that surveillance of communication or interception of communication or collection of personal data, including mass surveillance, should be done within the prescripts of the law and in line with the different states' international human rights obligations. So even when our governments decide to use such tools to limit the right of freedom of assembly, where it is absolutely necessary, those laws and the tools that are used must be in line with these internationally accepted tenets. I will end there, Abigail. Thank you.
Thank you so much, Makanatsa, for a very thorough overview. And I think you've not only given us sort of what some of the issues and emerging concerns could potentially be around surveillance and privacy, but you've also spoken of some of the good practice, spoken about what some of the measures that have been put in place with South Africa, for example, but also flagging a number of areas of concern, as well as pointing to the intention behind surveillance regulations, which are intended at their very essence to be about contact tracing, but could be potentially used in other ways. And I really liked what you said about the fact that these types of regulations should be time bound, that they should be destroyed, and that individuals should be given the opportunity to be notified that their information is being gathered and for what purposes as well. And thank you for recalling again the various resolutions that have been put in place by the United Nations on some of these privacy issues that are of relevance in this context as well. I'd like to, and I'm really hoping that we will have enough time, because I know that a lot of people would probably want to ask some questions. It's always the problem when you come to towards the end. And Stuart, I would really ask you, my question really to you is to find out from you, of course you are an academic that has written quite extensively on the issue of the use of force and protections of civilians. In your work and in what you're observing in the context of COVID-19, what are the standards on the use of force in the context of assemblies, and how do these standards relate to policing and managing protests, in particular during COVID-19? What are your observations? What are your thoughts based on, the extensive work and research that you've done in this area? If you could give us a few highlights, and then I will hand it over to our last speaker. Stuart, over to you.
Thanks, Abigail, and good morning, everyone. I realise that time is pressing, so I will try and keep it brief. I think the first thing to say is that the fact that there is a pandemic and that there are restrictions in place does not change the rules that govern the use of force for law enforcement. Let's look at those rules briefly. In implementing the rights to life and to freedom from torture and cruel, inhuman or degrading treatment or punishment, there are two fundamental principles that govern use of force in law enforcement: necessity and proportionality. Now, of course, there are many lawyers in the audience today, and they will know that these principles exist in a range of branches of international law. But it's important to recall that the rules, that the principles of necessity and proportionality as they govern use of force in law enforcement are distinct from these other branches. Firstly, with respect to necessity, there are three components. Use of force by the police must be for a legitimate purpose: to arrest a criminal suspect, to potentially disperse a violent assembly, and so on. When force is used, it must be the minimum necessary force. And thirdly, when force is used, it must only be for as long as is necessary. So when a criminal suspect is under control, for example, when he or she is handcuffed, then no further force is going to be lawful. On top of necessity comes the principle of proportionality. Now, this sets a ceiling on the use of force, even when that use of force is necessary. And it's especially relevant to arms that have a significant risk of death, notably, of course, firearms, but also electroshock weapons such as tasers. The rule on use of firearms is set out in a 1990 UN instrument, Basic Principles on the Use of Force and Firearms. And this is sadly one that is infringed in many countries and sadly in many assemblies. Use of firearms is only lawful where it is necessary to confront an imminent threat of death or serious injury, not to defend property, and certainly not to disperse a peaceful assembly. As Prof. Heyns mentioned a few minutes ago, the OHCHR has published guidance on other weapons, less lethal weapons, that can be used to lawfully disperse and lawfully arrest a suspect, but without recourse to firearms. These two principles, necessity and proportionality, are then underpinned by two principles that exist before and one that exists afterwards. The first of these is legality. There must be a law, a domestic law, that authorises the police to use force, whether it is for the purpose of arrest or in relation to public order. The second, which has been brought into play by human rights law since the beginning of the 1990s, is precaution. That means that law enforcement operations must be planned so as to minimize the risk of harm, both to individuals and to the law enforcement agencies. And then after use of force, there must of course be accountability. The right to life must be protected by law. That means that there must be a thorough and effective investigation, and where criminal wrongdoing is found, there must be a criminal prosecution. And the OHCHR published a couple of years ago the revised Minnesota Protocol on the investigation of potentially unlawful death, which I recommend to all the participants. That describes in detail the process, the character, the elements in an investigation, either where a death resulted or where there was a case of enforced disappearance. Now, Abigail was kind enough to mention the two websites that we have supported that set out the principles and the domestic regulation of police use of force and the right of peaceful assembly worldwide. Policinglaw.info and rightofassembly.info. I think Beryl may be kind enough to put those up on the chat. If you go to those websites, you will see that sadly, no state in Southern Africa, or indeed across the whole of the continent, fully reflects these fundamental rules and standards in its domestic law. Hopefully Southern Africa will be the first within the continent to begin to revise their laws to bring them fully into line with international law. In concluding, there of course is a heightened risk of abuse in situations of internal detentions or in a public health emergency such as we're seeing at the moment, but reiterate that the rules remain the same. There is no derogation from either the right to life or the right to freedom from inhumane treatment. And I'll leave it there. Thank you, Abigail.
Thank you. You've really broken it down, very complex issue and much debated, but you've really broken it down for all of us and reminded us of these recurring human rights key principles around the necessity and the proportionality of the use of force, and fundamentally that things don't change because we are under COVID. I'm going to thank the colleagues who are posting the various references that you refer to in the chat box. So colleagues, please feel free to save those links and refer to them as the discussion goes along. I'll also just notify Christof that you already have a question in the chat. I will bring that, give you an opportunity to respond to that once we've finished with this last presentation. But just to give you a heads up that it's a question already that is there for you. I would like to now really give the floor to our last speaker, last but by far not the least, and that is Priscilla, as I introduced her earlier on. Priscilla, national human rights institutions, of course, have a really vital role to play in providing oversight, you know, on human rights issues in the context of this pandemic. Of course, the Zimbabwean Human Rights Commission is an A-status institution according to the Paris Principles, and you are the Director of Monitoring and Inspections, as I already indicated. What would you say is the experience of the Zimbabwe Human Rights Commission has had in monitoring the right to peaceful assembly in the context of COVID-19? What have really been the opportunities and some of the challenges that you have been confronted with? I'd hand it over to you to give us the last presentation, and then we will open up the floor for comments and questions. Over to you, Priscilla.
Thank you very much, Abigail. As the Zimbabwe Human Rights Commission, as you have already said, it is the national human rights institution responsible for enforcing, promoting human rights in the country. So as the Zimbabwe Human Rights Commission, we have not been sitting on our laurels, but with the lockdown, we have been really active. We've been carrying out the monitoring work. We have been out in the field. In the first 21 days of the lockdown, the Zimbabwe Human Rights Commission requested to be allowed to go out into the field so as to monitor the human rights of all the citizens, because it's one thing to read something from the papers, to monitor the situation from the media, and it's another to really get the first-hand experience or the first-hand information from those on the ground. So as the Commission, we have been able to monitor the situation. So for the first 21 days, the Zimbabwean government passed regulations to ensure that, or to curtail the freedom of assembly and association. So these regulations, they imposed the total lockdown on the people of Zimbabwe. And during that period, the rights or the right to freedom of association and assembly was suspended. So groupings, including families, religious groupings, were also suspended. Easter holidays, you know, the 21 lockdown occurred during the Independence Day period and also the Easter holidays. So these celebrations and so on and the religious gatherings had also to be suspended. So in terms of what the regulations provide, these regulations provide that freedom of movement is banned. Only about 50 people are allowed to gather at a particular place. So it means that these 50 people, it's in relation to specific sectors, not all the sectors. So the informal sector, people are not allowed to be outside and to be gathering. In terms of politics, people are not allowed to be gathering for political purposes. So people are only allowed to gather when it comes to the right to health, accessing the right to health, accessing transport, and accessing hospitals and so on. So you'd find that the right to freedom of association has really been curtailed. And as a result, we have found that other rights have also been affected. You'd find that we received a lot of complaints that people are facing, they're not able to adhere to these regulations to stay at home because of the problem of hunger. Access to food, access to water remains a challenge for the people of Zimbabwe, and therefore you would find that the regulations sometimes are not adhered to. For the first 21 days, because of this problem, you'd find that people would gather outside and then the police would be called in to ensure that people are dispersed. We received a few complaints of people being assaulted by the police and being subjected to inhuman and degrading treatment. So following our monitoring visits, we then issued statements so that in these statements, we highlighted our findings and also reminded the government that even though we have not ratified the Convention Against Torture, our constitution still provides that freedom from torture is a human right that cannot be derogated from. So after our monitoring visits, we have done 4 of these. We ensure that we issue statements so as to direct government and to inform them of what they need to correct. And then the other issue that I would like to talk about, I've talked about the freedom from torture, cruel and inhuman and degrading treatment. In terms of access to health, you'd find that because of the limitations on freedom of association, some of the clinics and hospitals also started limiting the number of people or the people that could have their issues resolved at health institutions because maybe the health officials were afraid, they're afraid of contracting the disease. So we again raised this issue with the Ministry of Health and Childcare that there are clinics that are limiting this right to health, and people should have this access. People should be able to access hospitals and also be able to be assisted wherever they need assistance. We also found that because of the lockdown has really been tough on vulnerable, those that we call the vulnerable in our societies, the women, the children. Because of the lockdown, the right to education has obviously been affected because they cannot, the limits on the rights of assembly. Children are then found at home, and then persons with disabilities as well. If they are not able to go outside, if they are not able to assemble, what happens to them? So this brings in the question of assistance to vulnerable groups. And as the Commission, we have raised this issue that assistance should continue to be given to vulnerable groupings in society because of the restrictions on the freedom of assembly and freedom of association. And the government has been active in this regard, or they have said that there is assistance which is available. But as the Commission, when we went out and we assessed the situation, we found that a lot of people had not received this assistance, and vulnerability has increased because of the limits that have been imposed by the lockdown regulations. So we continue to monitor the situation as the Zimbabwe Human Rights Commission. We continue to monitor the situation because monitoring, for it to be effective, should be a continuous thing. And as the Zimbabwe Human Rights Commission, because we believe that reading for ourselves or reading what the situation is compared to getting the information firsthand would be very different. It's contradictory. So our interface with the public, we have been asking if they have the information on COVID-19. Do they have access to information? Do they have access to health? Do they have access to food and water, the basics that are needed? So that has been our experience as the Zimbabwe Human Rights Commission. I would welcome questions and any other issues that would be raised by others. Thank you very much.
Thank you, Priscilla. Thank you for the work that you are doing as a National Human Rights Institution, which is to continue the monitoring and protection work that you are doing, as well as the advocacy role. You know, I've noted that yes, indeed, the Zimbabwe Human Rights Commission has been issuing a number of statements, and also for really illustrating for us how lockdown is translating on limits of assembly, which in turn result in limits on education and assistance to vulnerable populations and other rights that are so fundamental to people's right to life. So colleagues, that brings our panel discussions or discussants to an end, we would ordinarily give them a round of applause, but I hope that you will all really congratulate them on what has really been a very good presentation on a number of complex issues. We have spoken about issues around surveillance, privacy, what the key standards are. We have given you an opportunity to have a flavor of the role of a national human rights institution. And of course, we've had benefited from our Special Rapporteur and the member of the Human Rights Committee to really lay the foundation on some of the overarching standards. I will ask Turuna, whilst I'm putting together the final list of speakers that would like to take the floor, to put up our next poll so that we can give you an opportunity to respond to that. And after that, Turuna, you can, as the questions are being posed, you can post up also the results. I forgot to call up the results earlier on, but we will do so for this next round. So the poll before you is there if you could choose 2 points that are most relevant for you on this issue of assembly, having listened to our different speakers. As I do so, please, those who would like to take the floor, please raise your hands. I've already noted 2 that would like to take the floor. If there are others, we will do so as they come in. Without further adu, I will give the floor. I have 3 speakers now. I will give the floor first to Fran Fanu. If you could unmute yourself. I believe this is a question that you had directed to Prof. Heyns. Please go ahead, unmute yourself, and then thereafter I'll give the floor to Sylvie and Admark. I hope those are your names. I'm just reading from the participant list. Thank you. Over to you, Franu.
Thank you. I'm Francesca. From Fanu is my Zoom name. Anyway, just to shorten it. But from the European Center for Not-for-Profit Law, thank you for the opportunity to be here. Yes, I brought my question to Professor Heyns as well, so it's basically there. My doubt starts from the consideration of the current draft of the General Comment 37 with regard to the derogations permitted to Article 21 in times of emergency. Because currently in paragraph 108 it says that if they are not derogated, if it's not specifically derogated, the right of peaceful assembly continues during the states of emergency and falls under the ordinary restrictions outlined in Article 21. Whereas if it is explicitly derogated, obviously there has to be further justification on why it is that. But my doubt comes from the fact that we are aware through our monitoring, we have ECNL and the International Center for Not-for-Profit Law, with which we work, we have a tracker of legislations on civic freedoms during times of restrictions during times of COVID. And we have seen that in some countries, restrictions of freedom of assemblies have been adopted because of the emergencies. So emergencies have been declared, restrictions adopted, and derogations duly notified. Other countries have declared an emergency, they have adopted restrictions, but they have not notified under Article 4, which is in their right. But then if you compare the type of restrictions introduced by these countries and by the countries that did notify derogations, they are practically the same, they are draconian. So, and they basically ban all sorts of gatherings during the prescribed periods, even of 2 people. There are countries where even going out on your own required the production of a certificate. So ultimately, it is not clear to me, and I wonder if there should be more clarity guidelines in the general comment itself, or when the restrictions adopted during times of emergencies on assembly are not justifiable under the ordinary restrictions imposed under the ordinary criteria outlined by Article 21. Currently, say those restrictions should be sufficient, but we believe that they are not, because in some cases they take place and the state of emergencies has not been notified. So that's the gist of my question. Thanks.
All right. Thank you. I'll give a couple more people the floor, because otherwise we will run out of time. If everybody could be as brief as possible to enable everybody to be able to respond. Now I'll give it to Sylvie. Sylvie, if you can unmute yourself and ask your question.
Yes, thank you very much. I have two questions. One is for Stuart and another one is for Professor Heyns. The first for Stuart is that we've seen a lot of joint police and military operations during the COVID-19 lockdown. Do you think there is need for a specific legal regime regulating use of force by police and armies during joint operations? And then for Professor Heyns, I've been reading the Collins-Kosa decision, and I've noted that one of the prayers for the applicants was for a set of rules regulating joint police and military operations during the COVID-19 lockdown. Do you think South Africa has done well in terms of setting the protocols regulating joint police and military operations during COVID-19? Or do you think there is a gap that needs to be filled in this regard? Thank you.
Okay, thank you, Sylvie. Admark? You can unmute yourself.
Yeah, thank you for the program. I have basically two questions which I'm going to ask in the Zimbabwean context. The first relates to the arrest of opposition members, including a member of parliament, after a supposedly unlawful assembly during COVID. I wanted to find out whether the commission has done any sort of investigation to find out what happened and what the government's response is. And then the second one relates to this continuous ban on assembly, but I have noted that, for example, Parliament is resuming its functions and will soon be inviting people to participate in the adoption of amendment number 2 to the Constitution while we are still in the lockdown. How is that justifiable? Whether that is justifiable, this question could be responded by any of the participants. Thank you for giving me the opportunity to ask a question.
Okay, thank you, Admark. I think we had another one. I think it was Neil, if I'm not mistaken. Let me just check. Yes, Neil. Neil, are you there? Okay, we seem to have lost Neil. Otherwise, I also noted that.
Sorry, I am here. If you can hear me now. Apologies.
All right, go ahead. Go ahead.
Very quickly, the UN human rights guidance on less lethal weapons in law enforcement was mentioned. How can this guidance be brought into operation by states in Africa, particularly Southern Africa and the region, to promote the appropriate use of force and ensure that, for example, SAPs or the military and all other law enforcement officials are both issued with the appropriate equipment, and to ensure that inherently dangerous weapons in South Africa, such as the double ball bullet, are prohibited? Thanks very much.
Okay, and then there were a couple of comments in the chat box. I don't know if Muyiwa wants to raise the issue that's in the chat box, or anybody else. But please do raise your hand. Otherwise, we will just take the questions from the chat. I have Avis and then Lloyd, and then maybe I will hand it back to the panelists so that we don't lose track. Avis, please unmute yourself. Avis? Otherwise, we can come back to him. Lloyd, do you want to take the floor? If you can unmute yourself, thank you. Okay, we seem to have Samantha.
Oh, okay. Thank you very much. Is it okay now, please?
Who's speaking?
Avis from Cameroon.
Okay, Avis, please go ahead.
Thank you very much. So we carry a study in Africa and the oversight country, and we observe that many countries are not yet revised the law on this subject, taking in account online space in the law. I want to know from the panelists, what can explain this timidity of countries to revise the law and taking in account the online space, as we are now on COVID-19 and this become more urgent. So thank you.
Okay, thank you, Avis. Lloyd, I don't know if you are able to unmute yourself. Hello, Lloyd. Otherwise, you can also type your question in the chat box if you're having a challenge. Okay, so let me turn it back to our panelists to respond to some of the questions. They've been quite a number. Perhaps we can give Christof the first opportunity, and whilst we're doing that, please also take the chance to see what the poll results are coming up as. Christof, I'll give it to you first, and then perhaps we can go around and give the other opportunity to the other panelists as well.
Great, thank you very much. Thanks for the questions. So Sylvie and Lloyd's questions, I think, concerns the situation that we had with the COSA judgment, which of course in itself was not a peaceful assembly. It's the enforcement of the lockdown regulations, but it is of relevance to peaceful assembly as well, and whether we have an adequate framework. So yesterday we had a panel discussion also involving the Deputy Minister of Justice and a number of other peoples on this very issue. And I think coming from the discussion, there's wide acceptance by the Minister as well that the South African laws, there are really 4 different pieces of legislation that deal with use of force, that has to be revised. And it's not just a question of the guidance or guidelines being given that was required under COSA, but more fundamentally that the laws need to change. That, for example, in terms of Section 49, that imminence is not required for the use of firearms, and at the Gatherings Act, the protection of property may result in use of firearms and so forth. And so the Deputy Minister told us that there is a process underway to revise the use of force laws in South Africa. We're not sure exactly what that entails, but he actually asked also for submissions on whether this should be done in the separate laws or whether there should be one piece of legislation that deals with all of that. So there seemed to be at least some kind of willingness to look at that. So yes, in short, I don't think the current South African legislation is adequate. What is required is laws that are in conformity with the international standards, but also then regulations that come from those laws. And that brings in Neil's point about the less lethal weapons, which is way too complicated to deal with all of it in the law itself. But if the law is changed and the law then provides that regulations must be adopted in terms of the law that comply with international standards, that leaves an opening for the less lethal guidance to come in. And so in this lethal weapons guidance, there are I think 3 particular forms of weapons that are declared that they cannot be used. This is not written in stone. This can actually be increased, and some people have, for example, also argued, in addition to the comments that you made, that the sjamboks, for example, in South Africa should be outlawed. So I think there's a space there. Francesca's question, so just to emphasize, as far as states of emergencies are concerned, that we in the Human Rights Committee do not necessarily, we do not regard if a state has not notified the Secretary General about a state of emergency that it cannot be tested. And there are many cases in which the Human Rights Committee has actually commented on states of emergency and whether they comply with the requirements of being necessary to preserve the life of the nation, and so forth. So of course, when one has a state of disaster like we have in South Africa, it's not a suspension of the right in question. It can still be challenged in court, but with an emergency, it can be derogated from. My own view would be that the limitations on Article 21 are so wide, as I've referred to earlier, that in most cases it can be covered there. But if a state then indeed feels that it is overwhelmed and it derogates his right, it cannot be taken to court to justify those limitations, then it still must meet with the requirements that are posed. But the preferable situation is that they use ordinary limitations and can be challenged in domestic courts and then can be challenged later on. I'm sure Clément will come in on Avis on online timidity, but perhaps just the other Clément that asked the question in the box about spontaneous assemblies, and he said, well, they inevitably turn violent, and why are they permitted? I think factually it's not true that assemblies inevitably turn violent. If one looks at South Africa, for example, last year 12,000 assemblies recorded. In 3,000 of those, it was registered by the police that violence occurred or potentially occurred and was treated as a potentially violent assembly. And in many other countries, the figures are actually lower. So I don't think there's a link that one can say it inevitably turn violent. But also, if spontaneous assemblies are not adopted, it's really the heart of the right that is no longer respected. So the ability of people to hear the news and to respond to it, if they have to go through the process of organizing for 5 days or something like that, one would really be taking out a very central part of the right in terms of them to express themselves. The challenge lies in making sure that this happens within a certain particular framework, but I don't think this can lead to a complete ban on that. Thank you.
Christof, and I will hand it over to Clément, our UN Special Rapporteur. If you could respond, and we'll also make this an opportunity for you to make any closing remarks, noting that we are shortly running out of time. Clément, over to you.
Thank you very much, Abby, and thank you also for many questions. I haven't been able to see all of them, but I saw that there is also one question talking about the meaningful consultation, and if within the COVID spread, isn't the consultation something idealistic? I just wanted to know that also when we call about the consultation, we are talking about every means that the governments will put in place to understand better, either from the civil society or communities. And we know that many of these decisions that was taken during the COVID time, they was also taken through the online, because many government agencies were not necessarily open. So the government did a consultation with many of them, sometimes involving the health personnel. But we think that since the COVID is not just a health issue, it should be important for the government also to put in place means. And we know in some countries the consultation happened online, and we know that also people were able also to respect the social distance and meet with some government. I don't think it's probably idealistic. And I want also to emphasize also that we are also seeing today, and I mentioned this in my presentation, that we may be in a situation where we need to live with COVID, the possibility of the COVID to spread or to come back again, or another kind of phases. So that's why it's important also that the government put in place a measure to ensure that while we are addressing the COVID, people are able to enjoy these fundamental rights. We saw in many cases that people are able to wear masks, they are able to ensure social distance when they are protesting. Because we cannot wait after 3 years, or even if we find the vaccine, we don't know what will be the effectiveness of this vaccine, if this vaccine will address the whole issue of the spread of this disease. So we need to be careful that we don't, while we understand the challenge the government is facing, we need also to be careful that we don't give a platform for repressive governments. And I mentioned that in 2000, you see the main problem for us is that some of the repressing government is taking advantage of that. So we need to avoid that by saying that, oh, we understand the health issue, or they can take whatever measure they want. So some governments will take advantage and completely crack down the democracy. That's why, for me, it's important. And then when it comes to the online space, as I mentioned before, it is important because it shows us this COVID that online space is equally important than the physical space. And without even giving the argument for the government that now demonstration can only happen online, we don't want physical, but we need to ensure that it's today we reinforce. And I really thank the committee for really taking this stand in terms of making sure that the general comments will spell concretely out the need to protect this space as the space that the fundamental freedom, peaceful assembly and association can be expressed. And I also think that COVID give us the opportunity today, and give the committee the opportunity also to review and to think a little bit about measures that governments take during this spread COVID time to understand better what should be the provision, what should be the concrete spellouts of measures that the government can take in an emergency situation. We saw some government that will not inform the committee, some of them that take advantage of this emergency, passing some of the law. So it has to be clear, spread out in the general comments. And I trust that is something that Christof Heyns, under his leadership, the committee is taking on board to really ensure that this experience of COVID provide a strong ground to the committee to justify why emergency situation is not, cannot be seen as a lockdown completely of fundamental freedom. The limitations are spread there, and they have to be proportionate. They have to be applied in a way that they do not come the rule, but the exception. So I think we need also to continue this kind of discussion to ensure also that we are on the same page, and we understand also the importance of all of us, experts, academics, all of us, to really help our government to address this challenge, but to ensure also that we don't give up on our fundamental freedom, because this is what we are seeing coming up with the repressive, and the post-COVID will be difficult. There will be a lot of protests going on because of the inequality, and we need to prepare and to provide government comprehensive tools that let them know that the excessive use of force is not allowed under the international laws. The restrictions are clearly narrow and should be the exception, but also that the protest is a fundamental right, and we cannot mix whenever a few people become violent in one protest. We cannot, it doesn't justify the use of force, and we cannot also say that the assembly itself is violent, and is the responsibility of the state, the law enforcement, to ensure that those who are coming violent, they can be taken away in order to allow those who want to exercise peaceful this right to continue. If not, we will see a lot of protests being disrupted by certain groups that doesn't want to see any kind of exercise of these fundamental rights. Thank you very much.
Thank you so much, Clément. Makanatsa, did you want to come in with any response? I think there was a question to you as well, and also if you want to just make some final remarks before we wrap up.
Thank you, Abigail. I don't think there was a specific question directed to me, but I just want to make an intervention in relation to the issue of governments taking up laws to protect online space, and why governments are not doing much to address that. I just want to say, in the context of the SADC region specifically, we have seen many governments coming up with ICT-related legislation in the region. And unfortunately, what we see with regards to most of that legislation is actually a focus on criminalizing online activity by citizens, especially if we look at the computer crimes and cyber crimes laws that are being put in place. in response to the SADC model law on computer crime and cyber crime. So the focus at the moment with regards to online activity by citizens, as we are seeing it, is not on protecting the online rights of citizens, but actually criminalizing online activity by citizens, which I think is an anomaly that really needs to be addressed. Thank you.
Okay, thank you so much, Makanatsa. Stuart, over to you for a response and some final comments.
Thanks very much, Abigail. I'll just quickly respond to some very good questions in the chat, some of which were presented. Firstly, on the issue of implementing the less lethal weapons guidelines, as Prof. Heyns said, there may be too much detail to deal with in legislation. You may need primary legislation setting out the basic principles, necessity, proportionality, precaution, and so on, but then referring to subsidiary regulations. And each weapon must be clearly regulated, how it is to be used, what you do in case somebody is injured as a result. Now, that of course begs the question, how do you achieve that legislative reform? And in practice, there tend to be three elements. A tragedy, whether it's an individual tragedy or a mass event. We've seen both of those in Southern Africa. Advocacy, and one of the presenters, Neil, has done some very good advocacy around less lethal weapons. And then thirdly, recommendations by regional courts or commissions of human rights. And there, I think there's a greater role for the African Court on Human and People's Rights. The African Commission adopted the General Comment on the Right to Life that sets out some of these principles. We need to go beyond that and achieve legislative reform. One of the questions or comments was about accountability. And here again, there is in some countries an oversight body, a body that is dedicated to looking at accountability, responsibility of law enforcement officials, particularly the police. However, it's not just a case of establishing the body. That body must be given sufficient resources and sufficient powers. Powers to command testimony and witnesses, power to look at scenes of death and so on. Question about joint operations with the military. It is very clear that when the military engage in law enforcement operations, exactly the same rules apply. However, of course, accountability for the military is a particularly tough hurdle to overcome. So both the African Commission General Comment and the joint special report by the Special Rapporteurs on freedom of association and assembly and extrajudicial executions specifically recommend that the military should not be engaged in policing assemblies. And finally, there was a question on proportionality, but I think in fact the question was more directed towards the notion of precaution. Proportionality, as I mentioned, looks at the instant of use. Precaution is going back in time and looking at decisions that were made by the executive. And while a certain margin of discretion will be given to the executive, they will be held to account, one hopes, for the decisions that were made. Thank you, Abigail.
Thank you so much, Stuart. We just have our last poll being put up on the screen. If you could just take the opportunity also to respond to that. I think it's giving us some very interesting results. I think we're getting to our last speaker now, Priscilla. There were a couple of questions. I don't know if you want to reflect a little bit on that, but if not, also to offer a few closing remarks as we wrap up this conversation. Over to you, Priscilla.
Thank you very much. So I saw the question on whether it's a challenge for the ZHRC, for the Zimbabwe Human Rights Commission, that currently the commission has no quorum, or that we have only a few, there are 4 commissioners less. So what happens then with adoption of reports? Yes, that is a challenge. That is why we have been issuing statements instead of adopting the reports. Issuing statements ensures that we reach out to our audience. The other issue was on freedom of assembly. Opposition leaders who carried out demonstrations sometime in April, whether the Zimbabwe Human Rights Commission received any complaints. Yes, the complaint that we received as the commission was on allegations of torture, inhumane and degrading treatment of 3 ladies who were at the forefront of these demonstrations, and investigations are still underway. So the Commission is still looking at that, and we're assessed with the issue. So those are the 2 issues that I thought I should respond to. Thank you very much, Abigail.
Thank you, Priscilla. Thank you again to our panelists who have really helped us unpack what is evidently a very complex issue. This really brings our conversation to a close, and we are spot on in terms of timing. So I'd like to thank all of you for your interactions. For me, I would just say that I perhaps have maybe 5 takeaways from this conversation. The one being to state the obvious, that COVID-19 is not just a health issue, it's also a human rights issue. But human rights must remain intact in the response to COVID-19. And the challenge that is upon states is to ensure that those human rights standards are intact, as we heard from Professor Heyns, that freedom of assembly is not an absolute right when declarations of states of emergency or disaster measures are being instituted. It is a right that is subject to limitations, but it must be justified. It needs to be content neutral, and it has to have this element of exceptionality. The second for me is really to say that we really need to pay attention to this issue of surveillance and privacy, as Makanatsa has highlighted, that such measures should be town-bound. There has to be an element of notification, and destruction of this information is vitally important. The third point is that to underscore that consultation matters, and it's not just because it's a good thing to do. It's also because it helps us understand the adverse impact of these exceptional measures and regulations in the context of COVID-19, which is going to become the new normal. The fourth point, as enumerated from Stuart, is that the pandemic doesn't change the rules on the use of force. The principles of necessity, proportionality, underpinned by legality, precaution to minimize harm and ensuring accountability remain at the forefront. And the fifth is this element of oversight. I think we have heard from Priscilla the role that a National Human Rights Institution plays in providing oversight in the response to COVID-19, that this oversight really needs to remain intact, as well as being accompanied by the standard operations of an institution of that type. Those are just a few thoughts from me. Of course, there's so much more to say. I want to also thank everybody who has posted the various guidance documents in the chat. I hope that we might have an opportunity to have another conversation in the weeks ahead together with the center. I'll ask Tiruna to post up our final poll, which is more like an evaluation of the session. If you could just take a few minutes to respond to that before we close the session. And finally, of course, to thank everybody at the Center for Human Rights, Franz, Tiruna, Yolanda, who've been working behind the scenes as well to get everything in order for today, and as well Anganile, my colleagues Anganile and Hannah, and the rest of the team in the regional office who've really been instrumental in pulling this off. And of course, by all means, our panelists, without whom we wouldn't have been able to have this conversation. So I wish you all the best. Stay safe, stay healthy, and let's all work together to build back better in a post-COVID-19 era. So that brings our session to an end, and thank you once again. Have a lovely rest of the day. But please do respond to the last poll.